And the first one will be by Dr. Robert GAITSKELL, who is a famous arbitrator, as well as an eminent lawyer and an electrical engineer. Dr. Robert GAITSKELL, he is a Queen's Counsel, and he practices from Keating Chambers, specializing in technology, engineering, and construction disputes, often of an international nature. He was called to the bar in 1978, appointed Queen's Counsel in 1994, and served as a recorder, that means the part-time judge, from 2002 to 2010. Robert predominantly acts as an arbitrator, adjudicator, dispute board member, and mediator. He is both a lawyer and a professional engineer. He is the editor of the famous book, Keating Construction Dispute Resolution Handbook. The current edition is third edition published in 2016. He is also a former vice president of the IEE, and he is also a member of the Singapore National Electricity Market Dispute Resolution and Compensation Panel. Robert is the chairman of a dispute board for a Euro 20 billion nuclear engineering project. He writes extensively and lectures throughout the world on legal engineering subjects, including at CERT in Geneva and Xerox PAR in Silicon Valley. With this introduction, may I ask Robert to tell us about benefits of engaging engineers in handling construction disputes. Thanks, Robert.
Thank you very much for that introduction. And I'd like to say what a great pleasure it is to have been invited to address the Hong Kong Institution of Engineers, a very highly regarded and venerable body. And there are many people in the audience I know that are old friends of mine. And so it's a particular pleasure to have this opportunity today. Now, my subject, which you've just been told, is the benefits of engaging engineers in handling construction disputes. And I'm going to speak on that for about 30 minutes, and then there's about 15 minutes for questions and answers. But the short point about engaging engineers in construction disputes is that engineers are absolutely essential. They have to be involved in construction disputes. Without them, the disputes simply wouldn't be able to be dealt with in any appropriate way. So engineers should feel very proud about the role that they play in dealing with construction disputes. They, of course, have one or two or both roles of being the adjudicator, the arbitrator, the tribunal, or the expert who is engaged by one party or the other to advise it and to produce reports on what the dispute's about and what the answer should be. So engineers are absolutely crucial to that whole process. Of course, there are other construction industry professionals involved in disputes, like architects, quantity surveyors, building surveyors, and so on. But very often, it's the engineers of all kinds, mechanical, electrical, chemical, civil, structural, that are absolutely at the heart of the dispute. And their evidence will be the material that the tribunal uses to finally come to its conclusion. Now, there are, as you've been hearing earlier today, a range of different dispute mechanisms. The ones we're all familiar with are court, arbitration, adjudication, dispute boards, but there's some lesser known ones as well: early neutral evaluation, expert determination, and mediation, of course. I'd like to say just a little about those 7 procedures before focusing in on what engineers bring to those procedures and why they are so essential, and what engineers need to do to make sure that what they're offering to the parties and to the tribunal is the most helpful input. So I'll go at very high speed through the 7, simply so that we've got them on the table for us to examine and discuss. Firstly, court litigation. Everyone knows how that works because you'll often see it in television programs, movies, and so on. And we're all familiar with judges and with advocates, barristers, cross-examination. So that's the default position. If you've got a construction contract that does not specify arbitration or some other mechanism, then that's where you're going to end up in court. We can park that because we're all familiar with how it works. Then arbitration. To go to arbitration, you need an arbitration clause within the contract. And all the standard form engineering disputes will invariably be based on FIDIC standard forms for big international projects. My own institution, the IEE-IET, which has a very big presence in Hong Kong, we produce the MF1 standard form, Model Form 1, and that's got an arbitration clause in it. And that's the norm, to have an arbitration clause, and that's why most construction disputes end up in arbitration. Then there's adjudication, and you've heard this morning a lot about how there can be contractual adjudication because it's specified in the contract, often as a first step towards arbitration, but you can have statutory requirements for adjudication, and of course that's what you've been hearing about now. So that's the third procedure. Then dispute boards. Many of the big international projects that Hong Kong has, while they were being carried out, the contract specified that if there was a dispute, it first had to go to a dispute board to get their decision, and if one or other party didn't like it, then you went to arbitration. And those tiered clauses, where you have tiers, where you it says in the contract you must try negotiation, then try mediation, then try a dispute board, and finally go to arbitration. Those are very common now and are very effective at disposing of disputes early on. For example, with mediation in the construction industry, there's about a 75% chance that if you go to mediation, you'll get a settlement. And similarly, if you then go to adjudication, although it's open to a dissatisfied party to go on to arbitration, in reality, very few parties go on from adjudication to arbitration. They simply accept what the adjudicator has decided. So having those tiers is very effective for disposing of disputes. And the previous speaker was emphasizing how important it is, if you can, to dispose of disputes before they turn into procedural difficulties that can arise once you're getting into arbitration and so on. Then mediation, I've already mentioned that. Expert determination, and this is an area where engineers are used on a regular basis and are crucial, absolutely vital. In my own field of power systems engineering, in various steps in the course of construction of a big power station, there'll be the possibility of disputes that can be solved very quickly by an expert determination by an appropriately qualified and experienced engineer. For example, it might be that the boiler is said not to come up to the contractual specification for its output. And you can get a boiler specialist engineer who comes in and decides that. He doesn't decide anything else, simply that. And it can be very quick, very cheap, and it's very helpful to the parties. Then early neutral evaluation. This is very rarely used, and yet in my own experience, it's very powerful. What you do here is you get an appropriately qualified person. It could be an engineer, could be a former judge or a senior lawyer, and someone who knows the subject matter, and the parties come in front of her or him for just 1 or maybe 2 days. They present their case very swiftly, without calling any evidence, simply explaining what it's about. And at the end of that period, the person conducting the early neutral evaluation gives a broad idea of what she or he thinks. It might be 20 million should be paid by party A to party B. It's not binding, but it gives the parties an indication of what, if they did go in front of an arbitrator or a judge, the result might be. And then they're able to use that as the basis for getting a deal. And I know that that particular procedure was very effective in getting a settlement in a big football stadium here in the UK, where it was causing real headaches to everybody, the construction dispute. And they went in front of a retired judge who gave an indication, and it settled straight away. So it's very powerful. All of those are covered in the book that, when I was being introduced, was mentioned, the Keating Construction Dispute Resolution Handbook. And if you're interested in the detail of those, you can read it there. Now, what I'd like to touch on for the moment is what you can expect as an engineer if you do get involved. You get appointed by one or other party to help it in a dispute. Well, if it's arbitration, which is, of course, the usual procedure for a construction dispute, then you'll be sent the pleadings, because those contain what each party says about its own case. So you can read those up. You'll also be given instructions from the lawyers who are engaging you. They'll tell you what the issues are that have been identified, and what they want you to ultimately write a report on. Having read all that material, if it's been structured correctly, you should then get the opportunity to go and speak to the expert appointed by the other side, because at that early stage, you're both on a learning curve, and you haven't committed yourself in writing as to what your views are. And it's very helpful, in my experience, at that stage, to talk to the expert on the other side, just the two of you, without lawyers there, and you can often identify lots of areas of common ground where you agree, because you're both engineers, you're both very experienced and learned, and you identify those areas where you agree and the few areas where you disagree. You then write a joint report identifying agreements and disagreements. Only after that do you have to produce your own report. And you focus then, of course, on the areas of disagreement, and you explain why you disagree. Ultimately, you come to a hearing, and your report is used as your evidence in chief. It's put in front of the tribunal, in front of the arbitrator, and you then get cross-examined on it. And if you've been honest in your opinions, you've done your homework by reading up the material, you've visited the site if you get that opportunity, then you can withstand cross-examination because you know exactly what it is you're saying. So that's how the procedure unfolds. And if you've done a good job, you will often find in the award produced by the arbitrator that he or she will comment on how helpful the engineering experts were in the material they produced. I'd just like to mention one or two things to bear in mind when you're being an expert. I've mentioned you've got to be honest. You've got to have integrity. Although you're being paid by one side, you're not there as a hired gun or an advocate. You're there because you've got the expertise that the tribunal needs. And if you are in any doubt about what your role is and why you need to be honest and act with integrity, you can get help from protocols produced by various bodies, such as the International Bar Association, the IBA, or the Chartered Institute of Arbitrators. All of these bodies produce helpful documents. And there's an English case called the Icarian Reefer about a scuttled ship. And that's got a very helpful list of things that you as an expert need to bear in mind. And that's widely available on the internet. Let me tell you one case which highlights how things can go wrong if you don't act with integrity. It's a case called B-Sky B against HP Enterprise in 2010 in the English Technology and Construction Court, dealt with by Mr. Justice Vivian Ramsey. And there was a witness there who claimed to have an MBA from an institution named Concordia College on the island of St. John's in the United States Virgin Islands. And he came and he gave his evidence, and now he's being cross-examined. And he said in cross-examination that he'd studied there on the island for 1995 to 1996. He used to fly into the island to attend these courses at Concordia College, and so on. The barrister cross-examining him then produced an affidavit from the head of the educational system for the government of that island, St. John's, and it said, we don't have an airfield, so no one could fly in here. There's never been a college called Concordia College here. There is such a thing on the internet. There's a website, but there's no physical college, so this made it look as though the expert had produced a fictitious CV. But things didn't end there. The barrister then said, now you got a 2-2 second class MBA, and he said yes. And he said, well, I went on that website last night and I put in my dog's name. The dog was called Lulu. I put in my dog's name And I managed to get her an MBA with a 2-1, a second-class degree of the first order. I paid more than you on the website, and I've got a better degree. Well, of course, the whole court collapsed in laughter, and all the evidence that this man had given for a long period in cross-examination was totally disregarded by the judge, who said so in the decision. So do remember that. I'll end with one last little story on that, this section. A colleague of mine was doing a case in London, and the expert was so destroyed in cross-examination that when there was a tea break, he ran off outside and has never been seen since. He simply disappeared. So do remember that you must maintain your integrity at all times. Now, what you will be thinking, I'm hoping, is that this is an attractive thing to do, to get involved as an engineer in disputes, because, as I've said, you are really needed, you are crucial. And if you want to get involved, there is a lot of help out there to make the transition from a pure engineer to an engineer who is involved in disputes fairly effortless. First of all, you can talk to people. Dr. Christopher Toe, who I know well, who's also a barrister and an engineer, talk to him. He's at the conference. He's speaking, of course, and he knows all about it. But your own institution, the Hong Kong Institution of Engineers, they can point you to people who can advise. And there are bodies, of course, that specialize in helping. The Chartered Institute of Arbitrators, the Academy of Experts, and so on. And there's a lot of help. And I do hope that you take this opportunity to consider whether you'd like to be involved in this sort of work, because you can contribute so much. And I am often phoned up from all over the world by people who say, I've got a problem with a turbo alternator blade where we're not sure that the metallurgy used when it was being created was absolutely right. Can you recommend an expert? And I have various contacts that I would then go to. But people all over the world are constantly on the lookout for specialist engineers who can help them with problems of this kind. And you could be the person who's going to solve their problem. Of course, always restrict yourself to being an expert in an area where you do have the expertise. There's a case, SP International and PPC, where shot blasting was the technical issue. And at the end of it, the judge said about the witness who'd been called on shot blasting, I doubt if there has often been an expert less expert than he. And you obviously don't want that said about you. So make sure you know what your expertise is, but then go through the training and become the person who can assist the arbitrator or the judge in knowing what to do about the dispute on your particular field. Now, I've talked for half an hour, but if there are any questions, I'd be delighted to deal with those.
Thank you, Robert. There are some questions from the floor for you, Robert. The first one is legal background or training necessary for engineer to get involved with dispute resolution? And any legal training you will recommend to engineer?
The answer to the first question is you absolutely do not need legal training to get involved. Virtually all of the experts who come along and give evidence in front of me when I'm sitting as an arbitrator or when I sat as a judge, all those engineers are simply engineers. They've got their engineering degree, their qualifications, their experience. They know all about shot blasting or turbo alternators or whatever it is. You don't need legal training. Where additional training is helpful is, for example, the Academy of Experts, which is an international body. They can train you in what to expect in those various steps I was telling you about, the pleadings and the reports and the meetings and so on. But you don't need a legal qualification. It's simply learning a new dimension to your current engineering skills. So you continue as an engineer. That is why you are being appointed as an engineering expert. Although people like Dr. Christopher Toe are both lawyers and engineers, people like that are very rare. Very helpful, of course, in cases where you need both qualifications. But the average expert engineer does not need any legal background. And insofar as you need to know what the law is, the people instructing you when you're appointed, they'll tell you what you need to know. So don't be put off by that. You can be an expert engineer with no legal knowledge, whatever. Right. Any other questions?
One follow-up question on this is that assuming the engineer is now acting as arbitrator or adjudicator, and the dispute involves some sort of on the interpretation of a contract. Now, we know that usually interpretation of contract involves question of law, but the engineer without the legal training is asked to make a decision on construction of law. What advice would you give to the engineer about this?
Yes, this can arise. The interpretation of contracts will often appear in one form or another in a big dispute. And if you've got a three-person tribunal, which is the norm for a big project, each party appoints their own arbitrator, and then the two appointees will choose the chair for the three. And usually within the three, you'll have somebody who is a lawyer. So you may be appointed by one of the parties as their arbitrator because you're an engineer with the right technical knowledge, and then the chair that you've appointed may well be an engineer, or an engineer, may well be a lawyer or an engineer lawyer. And so there will be someone on that tribunal that has got the legal knowledge to deal with the question of interpretation of contracts. If you're a sole arbitrator and you're an engineer and you don't have legal knowledge and you've got this issue of interpretation of contracts, what you can do, and I've seen it done, is you say to the parties, on that particular issue, I would like to engage my own expert who will report to me on that. And then you go to a very specialized lawyer who knows all about this particular form of contract and the wording in it, and you get his input, and you can then use that in your award. Because you'll have been appointed because there's a whole lot of technical issues, and you can deal with all of those yourself. But you can get independent help when you need it. So don't be put off by that. Thank you for that question.
Yeah, thank you, Robert. The next question is that as an experienced engineer, sometimes we are biased on certain engineering or construction-related issues based on our own knowledge or personal experience. As you have mentioned integrity a few times, how engineers should get it prepared before engaging in dispute resolution?
Right. Well, when you get appointed by a party to be their expert, you'll have come to their knowledge because you are a specialist in a particular field. So you've got your technical side already established. They've come to you because they have confidence that you know what you're talking about. They will then inform you all about the case itself by giving you the documents in which the parties have set out their cases. So because Hong Kong is part of the common law system, the usual way that parties set out their cases is in a statement of claim and then a defense and counterclaim, followed by a reply and defense to counterclaim, and so on. So step by step, as the parties present their cases on paper. And you're given all of that material, so you can read it up and you can see how the case has been explained by both parties. And then you are given the opportunity to talk to the expert appointed on the other side. And in my experience, that can be the moment when a whole lot of apparent disputes simply fall away. The two engineers get together and they start talking about the boiler output, and while they're chatting, because they're both very experienced and knowledgeable about this type of boiler, they'll chat and they'll say, yes, well, I think the problem is that the sand or the refractories or whatever are not what people were expecting. And there'll be a lot of agreement, and sometimes complete agreement. And then the parties are told, this is what both experts think the problem is. And if you go away and change what they've suggested, there is no longer a dispute. So you accumulate all the knowledge you need in a step-by-step process as you go through the procedure in the way I've described. And it can be very effective. Thank you.
Yes.
Next question.
Yes. The first question is, why is it in a party's interest to appoint a hired gun who wholly supports their case? What's the disadvantage?
That is a very good question, because a lot of people think that it's very much in their interests to have an expert who is a hired gun. But I can tell you, as the arbitrator, that it most certainly is not so. Because if you get an expert who is a hired gun and he writes a report saying, the party who appointed me are wonderful people, they've done everything correctly, there is nothing wrong with their product, this boiler is brilliant, it's the best boiler I've ever come across. If you get that, then it soon becomes apparent that this expert is simply a hired gun, and that his word can be totally ignored. I'll give you one quick example of this. I was acting as counsel for a party in a dispute about a roof for a big swimming pool for a famous private school outside London. And our Judge Newey in the Technology and Construction Court in London, he was up in the roof with all the lawyers and the experts, and there's this beautiful swimming pool below, and the hired gun expert that was acting on the other side from me, he was going on about how wonderful the workmanship was that he could see in front of him for this ceiling. All the joists were perfect and so on. And he said, I've never seen better work than I can see here. And the judge sort of raised his eyebrows. And so to demonstrate that he, the expert, had total confidence in it, he stamped on one of the joists, and the whole ceiling collapsed into the pool below. Fortunately, no one was swimming there. And the judge said quietly, I think this case will settle. And that's an example of somebody who is simply a hired gun and has lost their integrity. So you may think they're going to help the party that appointed them, but because they're going to be totally disregarded by the judge, they are of no help at all.
Yes.
Any other questions?
In fact, a follow-up question is that some experts tend to be argumentative. They stick to their theory, and they are not prepared to yield. But how would this be distinguished from what we call high gun? Although the other side will say this expert is a high gun, but actually it's just argumentative. Then what sort of distinguishing feature you would put at when you classify whether a person is argumentative or a high gun?
Very good question. Bear in mind that your tribunal will be in arbitration somebody who knows quite a lot about the subject matter. I'm often appointed as an arbitrator in power station disputes because I know all about power stations. And so if I hear somebody who is a hired gun saying something that is nonsense, I'll start engaging with him and saying, but why do you say that? And so on. Now, if he's a hired gun, then he's not going to concede anything. He's going to constantly say his party has done everything right. And that'll be evident to me. Whereas he can be argumentative and say, well, there are these reasons and those reasons. And if they're good reasons, then of course I'll understand them and take them on board and accept his evidence. And they may be good reasons. But it's for a hired gun, when he's argumentative, it'll be to defend the indefensible. And that becomes evident to the arbitrator very quickly. And once the arbitrator has decided the expert is a hired gun, his evidence is of no value and he does not help the party that appointed him.
Thank you very much, Robert. Thanks, Robert, for sharing with us your immense knowledge and experience in this field. May I invite the attendees to join me to thank Robert in the usual way. Thank you so much, Robert. Bye.